I'm going to pause it there to tell you about some new developments in Georgia, where the father of an accused high school shooter appeared in court asking for his trial to be moved out of Barrow County. Now, Colin Gray's attorney argued that widespread publicity would jeopardize his client's right to a fair trial. The prosecution actually agreed, but not because of pretrial publicity. So let's listen to both sides.
We have looked at the various stations, the news reports. If the court would require, we'll be able to get those together and bring them, but I think the court can take judicial notice of the amount of publicity that has been generated. Secondly, Judge, I'd like to point out that certainly this was a tragedy. This community came together and did an awful lot, fundraising-wise, GoFundMe-wise. I think when I checked last, it was over $1 million that had been collected. All of these things, Judge, go to point out that there was a lot of community feelings about the case. People who are willing to give money certainly would have a prejudice about what might happen in a trial of a case. For all those reasons, Judge, we would ask the court to grant our motion to change of venue. If the court does that, we'd like to argue over where we think would be an appropriate place to.
The state agrees in changing venue from Barrow County. However, the state does not agree to change the venue because of pretrial publicity. And there's a distinction there that will be used that addresses the remedy of what we should do. The reason the state is agreeing to change a venue from Barrow County is because all of Barrow County was a victim in this case. This was an attack on the school system, all the teachers, all the administrators, all the students. Just about every school on that day was in lockdown. Parents with children in elementary schools, middle schools, high schools across the county were worried about their child that day and was impacted by this. So therefore, we believe that because of the impact of the crime on Barrow County, that it would be difficult to find a fair and impartial juror, and it's the state's wish to try this case cleanly, one time, to bring justice for the citizens of Barrow County and the victims in this case. So therefore, we're agreeing to change the publicity, to change the venue, but not because of pretrial publicity. In Miller versus the state, 275 Georgia 730, court says that pretrial exposure to information about a criminal matter is not the same thing as pretrial exposure to inflammatory or prejudicial material that threatens an accused right to a fair trial. Being informed or even misinformed is not always the same as being inflamed or prejudiced.
So the judge did grant the change of venue motion, but he did not make a decision as to whether the jury will be imported or the actual trial will be moved to a different courthouse or a different county. Now, Colin Gray has pleaded not guilty to multiple charges, including second-degree murder and involuntary manslaughter. Investigators say that he actually bought the AR-15 style rifle allegedly used in the school shooting by his son only 7 months after the family was questioned by law enforcement over threats by his son to commit, quote, a school shooting. Now, on September 4th last year, Colt allegedly killed 2 students and 2 teachers while injuring 9 others at Apalachee High School. He is facing 55 counts, including malice murder, and he has pled not guilty. Colin Gray is just the 3rd parent in the country to be charged in connection with a school shooting by their child.